Non-answer. Welcome. Welcome to the Deal Doctor live stream, 1 o'clock Monday. Here we are. Recently, we've got a number of questions regarding purchase agreements, EMDs, and disclosures, and I thought it would be a good idea to review some of the answers we've given the agents out there. I'm going to get right into it with what is the effective date of a purchase agreement. For those of you who are on Facebook Connect, you may have seen a post last night about the effective date and how it impacts inspections. And I want to talk about that in regard to the various purchase agreements that we use at 5-Star. We have about 14 different purchase agreements, I think. It's in that range. And so each of them is going to interpret the beginning date, the start point of the inspection period differently. And I think it's really important to review this, and it's important for agents to know what their particular contract says. For example, the West Michigan Regional Purchase Agreement, the effective date is described as the date an offer is accepted and delivered to the other party. An acknowledgement signature is not required. Once they have reached a meeting of the minds, you have an enforceable contract. For example, buyer writes an offer and the seller accepts it as written, no counteroffer. You have a meeting of the minds. You have an enforceable contract. That is the effective date, whatever that date is. When you push that button and send it back to the other agent or share it, it is considered delivered by Michigan law the moment that you click send. So, however, on GCAR, the GCAR purchase agreement, for example, it's slightly different words, but essentially the same thing, that the effective date is the date that you come to a meeting of the minds. The first day following, the first full day, it doesn't go by hours, it goes by full days. The first full day is the day following the effective date. However, on the Northern Great Lakes purchase agreement, you'll find the effective date is a little bit unclear, in my view, per paragraph 25, if you look at that. Per Michigan law, as I said, the delivery occurs when you click send or share it in dot loop. The reason that this is important is that it establishes that starting point for inspections and other timed contingencies, such as the ordering the well and septic inspection, getting the title work to people, and so on, your buyers. But the Northern Great Lakes Purchase Agreement, the inspection window says within a certain number of days of the effective date. In that interpretation, or interpretation of that word, is that the effective date is probably the day they reached a meeting of the minds, when the seller accepted an offer as written or a buyer accepted a counteroffer from the seller. That's the day, that's the effective date. And the way that we're interpreting the Northern Great Lakes Purchase Agreement is that that is the day, the first day of the inspection period, that triggers the clock to start running. So, if you start to count out from those days, I mean, frankly, I use my fingers. I say, if today is the day that they sign the inspection, or they sign the purchase agreement, then tomorrow, the 14th, would be day 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay? And so the number, that date, which is going to be the 23rd, for example, would be the drop dead date for any addendum to be submitted by the buyer to the seller requesting some sort of repair or proposal. As I said, the Northern Great Lakes one is a little bit open to interpretation, so if you go down that road with your purchase agreement and it seems a little unclear, I would recommend that you, as the buyer's agent or the seller's agent, make it very clear. Put a specific date and time that this inspection window will close. Make it very, very clear in your offer or in your counteroffer exactly what that period of when that period for inspections starts and where it ends. So I hope that helps a little bit as far as the inspection period and how that is impacted by the effective date of the contract. Let's talk about personal safety. There were a couple of incidents last week where I think it's good to review some thoughts about how to protect yourself and keep yourself safe. No commission is worth finding yourself in harm's way. We tend to think of scary buyers who show up, and I think that you may have read the post on Facebook Connect about that, but we don't tend to give a second thought to going out on a listing appointment without knowing who these sellers are. And I think it applies both to open houses, or to sellers and buyers as well as open houses, and it's regardless of your age or gender. Anyone can be the victim of a foul play in our business. It's happened, and we have to be aware of those situations. Here are a few reminders on how you can stay safe. Number one, ask questions before you meet them in person. Get their phone number, address, a pre-qualification number. Ask them to provide their driver's license via text or email or in person, and they can, they maybe cover up their license number, but have some information that you can check that by using Forewarn or something else. When I started my career in real estate back in the 1980s, my broker had a policy in the Farmington Hills market that if you show homes to a buyer without having met them first in the office and copied their driver's licenses, you would be fired. That was his policy, and he stuck to it. It didn't matter how many houses you sold. If you put yourself in danger, in his view, by meeting a buyer without knowing information about them, you're gone. Now, we're not suggesting that that's what we're intending here, but I think it sends a strong message that it's really important for us to protect ourselves before we go out and put ourselves in harm's way. Forewarn.com is available on through a number of associations, and if you run the potential client or customer's information through the Forewarn database, it's going to provide you at least some background information if the potential client has a record. So if they refuse to give you their information, frankly, in my view, I wouldn't meet them. But that's my personal choice. But that's only step one. We've all gotten that phone call, can you show me your listing now, from a complete stranger. If you get that call, warning bells should go off in your head. It's important that you ask yourself how important your safety is to you. And for me, that's pretty high on my list of things that are important. So I say always meet a new buyer in a safe place with others present, preferably a 5-star office during business hours. But if you can't do that, make sure it's in public with plenty of people around. Never meet a buyer you've never met alone at a property, especially a vacant house. Get a photo of their driver's license and send it to a friend, a coworker, or someone, so that they have a record of who you were with, and even the license plate number. Text it to your backup agent, friend, partner, whatever, and we'll talk about that backup agent in a minute. But I think that's a really strong way to send a message to that buyer or seller that, hey, somebody knows where I am at. Somebody knows that I am with you, and they know how to track me down. Use a buddy system for showings. I think this was really evident of how successful it was in the post that was I mentioned last week, where one of our agents went out to a house, and fortunately she and her husband were both there when a buyer showed up, and it was a little disturbing and a little frightening that the buyer had a gun in the back of his jeans, and various other comments that were made. So if you have a buddy that you can say, hey, will you help me? I'm going to go show a house. Would you be there with me, just to sort of cover my back? And sometimes there's safety in numbers. So I think it's really important. If you have ever been in a situation where you feel as though you've been in danger, please share that information on Facebook Connect and with your association. What you share could save another realtor from harm. So I think it's really important to have a buddy whenever you're going to go out and show a house that may be vacant or even the sellers have left for the showing period, sort of thing. Some agents resort to or try to go to self-defense training. I think that's a really good idea, frankly. My friend was taught hand-to-hand combat to Army Rangers, and he was the first one to say that doesn't make you bulletproof. Martial arts is a last resort when you have no other means to escape or protect yourself. It's a last resort, as is carrying a firearm, according to state law. It's a last resort option. There are risks and liabilities, and you have to be sure that you are carrying within the confines of the Michigan law. Bottom line, be careful out there. It can be a dangerous world, and we certainly don't want to have any of our agents exposed and put in harm's way. I talked a little bit about the backup agent, and it's 5-Star's policy when you're away that you have a designated agent to cover your business. Nowadays, we do business all across the country, from home, vacation homes, in fact, all over the world. That said, things can happen in the process of having a listing or showing or the process of a transaction going through, which require boots on the ground and the ability to contact you. Last week, I got a call from a listing agent. There were 2 days from a closing, but the buyer's agent hadn't deposited the earnest deposit check into the broker's trust account. We managed to fix the problem and find a solution, but it would have been much easier if the buyer's agent had had a backup agent in place. We would have discovered that a lot earlier and been able to fix it a lot more easily. So having an agreement with another agent to cover the other's business while they're away, sort of a reciprocal agreement, I think is a great idea. And it's probably something as good business people that we should put into place sooner than later. Let's talk about EMDs. And this is a really, question about EMDs and getting the EMD refunded to the buyer or the seller is something that we get a lot of calls on. So I'm going to try to clarify a little bit here today about how we handle EMDs. The occupational code preempts the purchase agreement or an addendum. Let me repeat that. The occupational code preempts a purchase agreement or an addendum. So even though a purchase agreement says that if a buyer terminates based on inspections, they get their earnest deposit back, we still need a mutual release signed by both parties, because that's what the occupational code requires. If there's a dispute, a potential dispute, we can't release that earnest deposit simply because the purchase agreement or an addendum says we can. Now, even if we have an addendum terminating due to inspections, we still need the mutual release signed by all parties. If we don't have the mutual release, we must advise our client to seek legal counsel and settle the matter in court. So again, we get a lot of calls on this, but as the broker, we have to remain a neutral third party, and that applies to our agents as well. When it comes to EMDs, we have to remain a third party. We are required to collect the EMD according to the terms of the purchase agreement and deliver it to 5-Star upon receipt. The broker, 5-Star, has 2 days to deposit the EMD. Agents cannot hold the EMD for 2 days and then send it in for a deposit. That's a common misconception out there, and I'm hoping to clear that up a little bit here. If you're the buyer's agent and responsible to collect the EMD and deliver it to 5-Star, and you cannot get it from the buyer or it doesn't arrive on time, you must tell the listing agent. It is not information that can be withheld. Case in point, buyers terminated a purchase agreement when they discovered, per the appraisal, the house with 300 square feet less than the multiple listing data stated. Buyer wants their money back, seller refused to sign the mutual release. What can we do? Nothing. Our hands are tied. We can only advise the client seek legal counsel. We cannot simply release the EMD without the seller's signature. As an agent for the buyer, it's important that you exercise due diligence on behalf of your buyers by collecting and delivering the EMD for deposit per the purchase agreement. And make sure your client understands the time frames that the purchase agreement stipulates. Sending a repair addendum on the 16th day after the purchase agreement has been signed, when the inspection contingency is 7 days, may cause your buyer to lose out on getting their EMD back if they cannot come to terms. So, as an agent for the seller, it's important to make sure that the EMD has been collected and deposited in the broker's trust account. Always verify. If I'm working for my seller and I haven't reached out to that buyer's agent or buyer's broker to get verification that they have collected and deposited that earnest deposit, then that's kind of on me as a seller's agent that I have come up short with my fiduciary duties to that seller. If you tell a listing agent your buyer got cold feet or changed their minds, it will put your buyer in danger of losing their EMD. There's no contingency in the purchase agreement for that, and if you say these words to another agent, that agent could become a witness and opponent against you and your client to get the EMD dispersed to the seller. So, what do you say? 5 stars recommended best practice for terminating a contract due to inspections is using a two-step method. We've talked about this before, but I'm going to reiterate it today. The first step is an addendum terminating the purchase agreement. The buyer exercises their right to terminate the contract unilaterally by simply stating, the buyer hereby terminates contract based on inspections. It's that simple. You're not required for any other explanation. Not their cold feet, not their feelings, nothing. It's simply that they are terminating the contract based on inspections. And the second document, the second step, is a mutual release which stipulates who gets the earnest deposit. The reason why we do it in 2 forms is the 2-step process is the addendum terminating the contract stands on its own as a termination because of the language of the PA, because that paragraph in the purchase agreement specifically states that they have the right to terminate the contract unilaterally. In other words, they don't have to have the agreement of the other party. A mutual release, if you'll notice very carefully, a mutual release is not enforceable until and unless all parties have signed. So if you send over that mutual release, it may or may not be interpreted as bona fide termination of the contract. And so we've, upon the advice of our attorneys, have said the 2-step method protects us as the buyer's fiduciary partner to make sure that the documents, the purchase agreement is terminated appropriately, and the mutual release will identify who is going to get the money. Okay? That's how it works. Lead-based paint disclosures. So I just want to check my time for a second here. Lead-based paint disclosure. It is a federally mandated disclosure that a home built prior to 1978 must disclose any knowledge or records about lead-based paint in the home. It is often confused that the lead-based paint disclosure has the same exemptions as the Seller's Disclosure of Condition Act. And I want to be clear that that is not the case. The Seller's Disclosure Act is a Michigan state law with its own exemptions, but the lead-based paint disclosure has fewer exemptions as is a federal law. So keep that in mind when you're identifying who is going to have to sign the lead-based paint or the seller's disclosure. In the case of the lead-based paint disclosure, the only exemptions are dwellings with no bedrooms, like a studio apartment, housing for less than 100 days, in other words, short-term rental, housing for the elderly where no minor children will reside, and rental units which have been found by a certified inspector to be free of lead-based paint. That was a tongue twister. Anyway, it does not apply to single-family homes and condos, only rentals. So we had a case this past week, a house built in 1941. Listing agent and broker thought that because they had provided a report from a certified lead-based paint mitigation company, the seller was exempt. They are not. The seller is not exempt. They should have completed the lead-based paint form stating that they do have knowledge of lead-based paint on the property and they do have records, and then provided the verifications of the lead-based paint removal to the potential buyer. That's what should have happened. It didn't. Listing agents are also required to sign that they have advised the homeowner of their duties in that little midsection of the lead-based paint disclosure, that we've advised them of their duties under the lead-based paint disclosure law, including the homeowner's duty to disclose any knowledge and or records about lead-based paint, and to provide a copy of the EPA pamphlet, Protect Your Family from Lead in Your Home. Now, for those of you who are working on the listing side of contracts, I would say, are we providing that? It's obviously the seller's actual duty to provide it, but very often we agents have been providing that for sellers to share with potential buyers, and they do that through a link to the HUD regulation or whatever. I mean, they can provide it as a PDF and so on, but that really is something that sometimes gets pushed aside and not dealt with, and so we just need to be aware that the seller does have a responsibility to provide that EPA pamphlet. If you list a home built in 1978 or later, are you required to fill out any form at all? No, period. There are a lot of brokers who will demand that your seller sign the box at the top of the lead-based paint disclosure form confirming the house was built in 1978 or later, but it is not required. It is not required according to the law, and you cannot force anyone to sign anything. As I said, there are a lot of brokers out there who think that the seller must fill out the top of the lead-based paint disclosure form. Again, they don't have to, but sometimes it's easier to simply provide that than fight the battle. Keep your eye on the prize. Getting the sale closed for your client and getting paid for your work is really our objective here, not to get into the fine points of the law. So sometimes you may decide, you know what, it's not worth fighting the battle here. Material facts and latent defects. These are words that are bandied about in our business a lot, and sometimes without real clarification about what they mean. So I'm going to help. A material fact is anything about the property that could affect the decision of whether to purchase the house or affect the offer price. It's a material fact, anything about the property that could affect the decision whether to buy or affect the price. It's something that maybe happened. It could be something that happened in the home, a suicide, homicide, ghost sighting, but we are not required in Michigan. We're not required in Michigan to disclose any of those things, and it is also something that is coming to the area or anything that may affect the property value. In short, a latent defect is something wrong with the home, and a material fact is something that could change the buyer's mind about buying the property. We must disclose latent defects. We are required by law to disclose them. So, for example, if they have a leaking basement, we don't have a right not to disclose that. We can't keep that as confidential information for our seller client. We have to disclose that information. Here's an example. After reaching an agreement on a purchase agreement regarding a client's duplex, the listing agent discovers the renters on both sides of the duplex are 3 months behind on their rent. The seller intends to take the security deposit as partial reimbursement. The purchase agreement calls for all security deposits to be held by the seller and to be transferred to the buyer, as well as a proration of rent. Buyers under the impression they're going to get thousands of dollars in security deposits and rental payments, but no, there is no money left. the listing agent, is the listing agent required to disclose that? And the answer is yes. That's really a material fact, or even possibly a latent defect, that the buyer has a right to have that information. So, does the seller have any right to keep the EMD if the buyer terminates on that basis? And the answer, in my view, is no. The buyer has a right to terminate based on the new information. This is like filling out a new disclosure form because you just discovered that the basement is leaking for the first time last Tuesday. Well, you have to fill out a new disclosure form that gives the buyer a window of opportunity to terminate the contract according to the terms of the seller's disclosure form. So it would be no different than the seller filling out a new disclosure form after they have discovered a leak in their foundation. So, 25 minutes. I knew I was going to be moving fast, so I apologize. It was a lot of information in a relatively short period of time. I guess my question is, do you have any questions? No questions. Okay. That may take a couple of times through to catch everything. I know that there's a lot of information there. And I do want to mention a couple of things. We got some kind of interesting live streams coming up with some other of our five-star agent and broker support group. I hope you'll tune in over the next few weeks, and it should be kind of fun. And I hope it's kind of a new twist that we can make these sessions interesting and fun. So thanks for joining, and I will see you here next week.